I'm Brian Dickerson with the law firm of FisherBroyles. Myself and my partner Tony Calamunci head up the Health Law and Pharmacy Law Group. We represent pharmacies, manufacturers, wholesalers throughout the entire country, whether it be from Board of Pharmacy issues, Department of Justice, Office Inspector General. We handle litigation. We handle the transactional side. We help set up pharmacies. We do the contracts, employment agreements. We also deal with mergers and acquisitions when a pharmacy wants to sell or when a pharmacy wants to acquire another pharmacy. So we handle everything A to Z for the pharmacies, and we have probably one of the best teams that you can imagine nationwide helping the pharmacies, manufacturers, and wholesalers. Well, I think we have to look at the fact that the Department of Justice right now is making money for the federal government. President-elect Trump is going to continue that. He's going to need to continue that. With Sessions being known as an aggressive prosecutor when he was the Attorney General for the state of Alabama and also U.S. Attorney for the Southern District of Alabama, I think he's going to continue to be aggressive. Right now they have enough litigation in the pipeline and investigations that I don't think much is going to change within the first year. We just saw Ms. Yates, Deputy Attorney General, emphasize again that they're going to be prosecuting individuals as well as corporations. So I think we're going to see that continue. Now, after Sessions has been in there a year, they may change some of the focus, but the next 12 months, 18 months, expect the aggressive fraud, waste, and abuse prosecution that we've seen the last 8 years. Well, the one thing you have to look at is this. Everybody talks about compliance programs. The issue is it a viable compliance program that the Department of Justice and/or DOD, Office Inspector General, will honor? So there are guidelines and factors that must be in every compliance program. And what we see, unfortunately, is a lot of pharmacies, manufacturers that get these compliance programs either off the internet or some other pharmacy had it and they just copy it. The problem is it is required that the compliance programs be independent to the actual pharmacy, tailored to the pharmacy. When you buy them off the shelf, buy them off the internet or copy, it's not going to be that. So when we're defending cases, and we have a viable compliance program, I can go to the government and say, Board of Pharmacy, whomever it is, here's the compliance program. If something went wrong, it's not the compliance program's fault, it's not the pharmacy's fault. We have to adjust. But it's a viable defense and it's a permissible defense under the United States sentencing guidelines. So pharmacies need to take it seriously and they need to make sure their compliance program is adequately prepared, but most importantly, that it's audited as well. You can have a piece of paper telling you what you're supposed to do, but if nobody's checking it, there's no checks and balances, it doesn't mean anything. So when we implement a compliance program, we not only implement it tailored, but we also have audits set up and a compliance officer doing those audits. Same with HIPAA. With HIPAA right now, these pharmacies better have a HIPAA compliance program and a separate privacy officer. If they don't have the separate privacy officer, they're not in compliance. And if they have a breach, they're going to be in difficult problems because if they don't have the compliance program, you can't go to the Office of Civil Rights and say, we had it in place, it was just a mistake. Instead, they're going to look at it as being more reckless, and then there's going to be more fines and penalties, which can mount up to $1.5 million. Well, fortunately, pharmacies know from all of the investigations, the indictments, the criminal prosecutions, the last 4 years, the pharmacy world was introduced to the marketers. And I use that term because there are a lot of them are former pharmaceutical reps that were used to dealing with the pharmaceutical manufacturing world, which has different rules and regulations. They both have the anti-kickback statute though. And unfortunately, the majority of pharmacies that got tied with marketers did not understand the anti-kickback statute. So they were paying the marketers based upon a commission basis. You can't do that. They also had them as independent contractors. You can't do that either. But to the defense of most pharmacies, they were getting counsel from lawyers who were not healthcare lawyers, who did not deal with the pharmacy world. And they were just giving them basic contracts, and they were going forward with those contracts. So the investigations right now are basically focusing on, is it a viable contract? Is it a W-2 employee? Is it a true W-2 employee contract? Then what is the compensation? Is it fair market value? Pharmacy can have a contract and it can say it's a W-2 employee, but if they're paying the rep 50, 60% of the reimbursed rate, that's not going to be deemed viable by the Office of Inspector General or the Department of Justice. So the marketing prosecution is the most aggressive right now. The Department of Justice is consistently going after investigations and having the marketers tell the government about what other marketers they did business with, what other pharmacies they did business with. So imagine there's a domino effect. One marketer gets caught up and tangled in this web. He tells about another marketer, and that domino effect just keeps going. Now the sad thing is, a pharmacy may have done everything legal that it could have done and could have caused to be done. But if they have a bad marketer that was at their pharmacy, it may draw attention to them. So what they need to do in the future is this. They need to have W-2 employees if they're going to have marketers, all right? Then those marketers have to be trained, fraud, waste, and abuse, and HIPAA, and their compensation has to be fair market value. If they don't have those met, then they're going to expose themselves to extra liability from the Department of Justice standpoint and also from the PBMs. The TRICARE billing issue with the compounding pharmacies has, of course, drawn attention to all compounding pharmacies and drawn negative attention. The marketing of the compounding pharmacies has also drawn negative attention. So since TRICARE has basically limited its reimbursement, the other insurance companies followed suit because they then learned of these issues. And what you then had is a lot of private companies. You have banks, insurance companies, who were paying the same reimbursement rate for compounding pharmacies as TRICARE was, the Department of Defense. But when these Department of Defense investigations became known, then these other insurance companies, these other privately held companies, stopped reimbursing. So the reimbursement is the key for pharmacy. You can get a prescription, you can fill it, but if you're losing money, it's not viable for the actual pharmacy. So that is where the die-hard issue is where's the reimbursement going to come back? Where are the formularies going to come back? They slowly are, but they'll never be what we saw from the 2010 to 2015 time period. So then with 503A, what you have to look at is the actual compounding. Those laws are going to stay the same. You're not going to have any type of change in that, where the pharmacy has the ability to do the compounding, the physician has the ability to do in-office dispensing. That's all regulated by the states. So that's going to continue. But what you're going to see is, are they going to continue to actually do this type of compounding because the reimbursements aren't there? And that's where you're going to see a lot of compounding pharmacies fall to the wayside. And the ones that actually are compliant with 503A, are compliant with state, federal regulations, are compliant with the insurance contracts, those are the ones that are going to succeed. Every pharmacy is going to be audited, whether it's from the Board of Pharmacy, FDA, or a PBM. The key is to be prepared for it and be proactive. So when an audit response needs to be prepared, it is best to have counsel prepared, especially when it's a BOP or FDA. PBMs, there's a lot of just simple responses that can be provided to the pharmacy. However, if it's a PBM audit where they're actually asking for money back, hundreds of thousands, millions of dollars, you need to get counsel involved, and you need to get them involved right away. So when we're involved with an FDA, BOP, or PBM response, what we can do is help formulate the legal response and the strategy that needs to be provided. You don't have to disclose everything on the first response, and you have to decide what needs to be responded to and what can be provided to those agencies. Where we always get brought in is either our response is due in 24 hours, or we gave them this response and they come back and they want to terminate our contract because of something that they provided to the PBM, or Board of Pharmacy is asking for a hearing now because we gave something that we shouldn't have given to them, or there's just a bad information exchange. So the best thing to do is when they receive that actual audit request, get counsel involved immediately. And it's better to pay that penny up front than pay a lot more later. Well, we talk about compound pharmacies, we talk about pharmacies. What we saw or the trend in the last few years is this telemedicine developing. Telemedicine is legal in specific states and they have their own guidelines. That's where medical necessities come up the most. Was there a patient-physician relationship, a true physician-patient relationship? Or were these prescriptions just provided by this doctor who really didn't spend time with the patient, didn't know the patient? These investigations that are going on, that's the question, medical necessity. does the patient actually need the prescription? Is that product going to cure or help whatever is ailing the patient? And moreover, what we learn is a lot of these prescriptions that were received by the pharmacies and filled by the pharmacies, there wasn't a true patient-physician relationship. And that's where the government, Board of Pharmacy, and the PBMs are attacking the pharmacies. So moving forward, what pharmacies need to do is, if they get a new doctor that they've never seen a prescription for, they got to do a little due diligence on where this doctor is, why he's writing this prescription. We have cases where we have physicians where the pharmacy really hasn't done the due diligence to figure out, should that physician have been writing that prescription? An example, an OBGYN who's writing a prescription for a cream that is for a male patient. Should be something that a pharmacy should pick up on. The PBMs do pick up on that. The Department of Justice does pick up on that. So the pharmacies need to be proactive in seeing, all right, do we have a relationship with this physician? If we do, we trust him, keep going. If they don't have a relationship with that physician, they need to see what that physician background is, why they're writing the prescription, talk to the physician, get to know the physician. That's a key. Now, if they're getting a lot of new prescriptions from a specific physician, they need to figure out why all of a sudden they're getting this influx. What you had in the past is pharmacies were just happy to get all these prescriptions, so they didn't ask these questions. They're the same questions that need to be asked when you're dealing with a controlled substance. Why are we receiving these prescriptions from this doctor? Should he be writing these controlled substances? It's the same with any prescription, whether it's a specialty prescription, whether it's a compound or controlled. You need to know, as a pharmacist, the relationship with your actual physician and what that physician should be writing and is writing. When you're proactive like that, then you address that medical necessity. So when you get a PBM audit or a Department of Justice investigation, that civil investigative demand asking you about these patients, you can already have that ready. You can already have that in your actual files as to talking with that physician and that you have a relationship with that physician and why those prescriptions were written.
Hi, I'm Anthony Calamunci. I'm a partner in the law firm of FisherBroyles. I head up the health and pharmacy team with my partner, Brian Dickerson. We have a number of lawyers that cover the entire state and country, and we represent a number of independent pharmacies, manufacturers, and wholesalers. We deal with this every day. There is an ongoing war with PBMs and independent pharmacies and the pharmacy industry in general. PBMs traditionally were the gateway between the pharmacy, the patient getting their medications, the wholesalers, and the distributors. What's happened is, because now over the years there's been a number of acquisitions where the PBMs now own their own pharmacies, which creates an inherent conflict. So the problem is now, where they were providing pricing, they were providing support, they were providing a service, now they're eliminating certain independent pharmacies and specialty pharmacies and driving that business predominantly to their pharmacies. So we're seeing that conflict of interest play out. We believe in 2017, legislative and/or litigation solutions will appear. This has to change. There are certain mergers and roll-ups that are going on in the industry right now that we see are changing. But ultimately, because the traditional role of the PBM, the pharmacy benefit manager, was that to manage, to maintain pricing, to use its purchasing power. And what we're seeing is they're really manipulating the process to maximize their own profits. We're hopeful in 2017, based on our efforts and others like us, this is going to change. Well, the first thing they need to do is understand the reason in which they're being terminated, because a lot of times there's confusion in the notice. They got to look at the actual contract. And often, unfortunately, this is the first time that a pharmacist looks at their contract. If they haven't been forewarned, either in an audit process or some other process, they need to obtain counsel. They need to understand why they're being terminated, and more importantly, understand the impact this termination will have, if it's effectuated, on their other PBM contracts, their other third-party payer contracts, because there's a domino effect. There's a domino effect in the industry. They also have to, because they have an obligation to their patients, especially if they're a specialty pharmacy with a pain management plan in place or with a chronic disease management plan in place, to assure that both the replacing pharmacy and they are providing enough product and there's a continuity of care to the patient. That duty resides to all the healthcare providers, regardless of the contractual obligation. So it's very important to dot your I's and cross your T's and not just say, well, we're going to be out of network now, or concede. We also have had situations where PBMs make mistakes, third-party payers make mistakes, that they allow the reinstatement, that there's a reinstatement plan in place, that we create a corrective action plan if the basis for the termination was something that was done from a compliance perspective. So when they receive that notice, it's not the end of the world, but you've got to plan for it and you've got to get counsel immediately to make sure you're going down the right path. Well, it's changed recently, and particularly the largest PBM in the country, ESI, Express Scripts, redefined home delivery as mail order in their contract with their pharmacies. What we find is a number of pharmacies aren't paying enough attention to the detail within their contracts. But what's ultimately happening is Express Scripts, as the largest mail order pharmacy in the world, is driving the mail order business particularly to their side. So as a PBM, they're regulating what they're calling home delivery and mail order credentialing. And we try to help the pharmacies to understand that A, they have to be licensed in the states in which they are dispensing medications. And if they're using a third-party courier, UPS, direct, FedEx, whatever that would be, that would probably require that they become credentialed as a mail order pharmacy. So these are all issues that are arising. They have to be cognizant of their contract, and this is something that is it's changing, and we're seeing a lot of PBMs moving to eliminate pharmacies from their network, utilizing this tool being the direct mail distinction. The federal government authorizes the issuance of something called a CID, a civil investigative demand. It is a request for information. It doesn't make specific findings or allegations. It's a due process. What we're finding is the effect of this, because the CFR holds that when there's a civil investigative demand issued, that TRICARE particularly can hold back its reimbursement. So they'll suspend reimbursement, not terminate the contract as a TRICARE provider, but suspend payment. So the problem is there's now this gray area where people that are in the situation where they're receiving, particularly pharmacies, who are receiving civil investigative demands and they don't know what to do, they have to get advice, because it could trigger their requirements that sit within their PBM contracts to notify all the PBMs that there's been an action taken by a third-party payer or administrator. Because that's really what a PBM is. It's a third-party administrator. It's a TPA for the various insurance entities. So it's very important to understand that, and that's where we're seeing, particularly in this little segment of CIDs being issued more and more, as the federal government is using them as a tool to investigate pharmacies and marketers and all people involved in the industry, in the healthcare industry, and particularly anti-kickbacks, medical providers, prescribers. All of these people could qualify under the issuance of these CIDs, and it has a number of effects on them as an ongoing federal investigation exists. So it's important to get counsel, it's important to get help, and it's more important to understand that this could have wide-ranging effect on your contracts. More and more, we deal with pharmacies that don't understand what their contracts say. They need to get help. They need to have those contracts reviewed. PBMs change their contracts. Third-party payers change their contracts on a regular basis. They feel helpless, unfortunately, because these are one-sided contracts, and they don't feel as if they can negotiate. So the term is, why does it matter? If they're not going to change terms or negotiate terms, why does it matter? Well, it's important to understand the scope and understanding. Like when you talk about the issuance of a CID and knowing that it could be deemed a termination of an agreement with a third-party payer requiring notice requirements, these are very sophisticated terms that have triggering effects, domino effects. So it's just important, and we advise our clients, ignorance is not an excuse. You have to review and understand your contracts, and if you don't, find somebody that does. Don't go to a real estate lawyer. Don't go to your brother-in-law because he has a law degree. Go to someone that understands these provisions, understands their application, understands how it's going to affect you in the industry to make both business decisions and legal decisions as you move forward. It's very important. We utilize the OIG, as a number of people do, to get guidance, particularly in the False Claim Act arena. The federal government investigates fraud, anti-kickback. It's really a bribery statute. What it says is you can't give unlawful remuneration in exchange for a script as it relates in the pharmacy business between a potential marketer and a potential pharmacy and a prescriber, maybe a doctor. What's happening more and more as it relates to the OIG, they give a lot of guidance on what you can and cannot do. Where this becomes more complicated today is that there's another federal healthcare fraud statute, and that's 18 U.S.C. 1347, which is the generic healthcare fraud provision. And the OIG doesn't give specific guidance into that law. They deal with the federal statute, which is the anti-kickback statute. So what we're telling people more and more to say, you may still be violating federal law if you've created a business model, even if it's in a private pay segment and not a government pay segment. So this is evolving, it's highly sophisticated, and it's very important for people to understand the OIG is there. We utilize it regularly. We actually, on behalf of clients, prepare and request opinions because it's going to do one of two things. You're either going to get a roadmap on how to do it right and in compliance with federal law, or they're going to reject it, and it's going to be like, well, you're telling me now I violated the law when you wouldn't even give me any guidance when I requested it. So more and more, we're utilizing the OIG as a tool to allow pharmacies and people in the health industry to give them a roadmap and a guideline for their business planning and compliance. Another recent trend is that as these PBMs are eliminating independent pharmacies from their network and terminating them, they're not putting in place continuity of care plans. The specialty pharmacies we represent provide a very interactive role with the prescribing entity. For example, we represent a pharmacy that does cystic fibrosis. That's a specific disease management profile. And what the problem is now the states, understanding that continuity of care is important, have put statutes in place which we believe the PBMs are potentially violating because they're not putting continuity of plans in place for the pharmacies that will be covering if the pharmacy is in fact removed from the network. So continuity of care right now is underappreciated, it's not being managed, just like the primary care issue and just like the PBM issue. The patients are being last. The patients are not treated with the priority that's necessary in this issue. So we have raised these issues on behalf of patient advocates and the pharmacies to make sure that these very important chronic disease and specific disease management profiles are being available for the new pharmacy coming in if in fact the pharmacy, the independent or specialty pharmacy is being removed.